Welcome to my rant today about privacy rights and the protections of personal information here in Canada. I'll be talking a lot about the new Digital Privacy Act, or Bill S4, which was passed in August 2015, which is the federal government's latest attempt to reform PIPEDA. I would also like to explain where this act falls short, especially in education. In the Canadian Charter of Rights and Freedoms, there isn't any specific mention about privacy or the protection of personal information. However, it does afford protection under Section 7, the right to life, liberty, and the security of the person, and Section 8, the right to be secure against unreasonable search or seizure. Canada has two federal privacy laws. The first is the Privacy Act, which covers the personal information handling practices of the federal government, departments, and agencies. And the second is the Personal Information Protection and Electronic Documents Act, also referred to as PIPEDA, the federal private sector privacy law. The Supreme Court of Canada has stated that the Privacy Act has quasi-constitutional status, and that the values and rights set out in the Act are closely linked to those set out in the Constitution, as being necessary to a free and democratic society. The Government of Canada compiles a huge array of personal information about you, and it's more than just your name and your address. For example, some of the information is gathered when you fill out your tax return or when you apply for a government benefit. But in general, your personal information should only be collected, used, and disclosed with your knowledge and often with your consent, for legitimate purposes only. It must also be stored, shared, and disposed of in a way that keeps it secure and confidential. The recent breaches of personal information in retail giants like Target and Home Depot, where the credit card information of millions of Canadians were stolen through malicious software, show that there is a real need to update the rules for online privacy, especially in the private sector. This is where the Office of the Privacy Commissioner of Canada comes into play, who is responsible for protecting and promoting people's privacy rights. The Commissioner makes sure that businesses comply with the Personal Information Protection and Electronic Documents Act, or PIPEDA, which I talked about earlier. Basically, PIPEDA establishes the rules for how businesses handle personal information. While there will be challenges addressing all these changes to the new Digital Privacy Act, there are two challenges which I'd like to focus on now, highlighted here in yellow. The first change is that the new law requires the organizations to keep and maintain a record of every breach of security safeguards involving personal information under its control. The second one is that it establishes that an individual's consent to use their personal information is only valid when it has been collected in such a way that the individual providing the consent fully understands the consequences. The problem with the first change is that most of the criminals are very good at what they do, and in most cases you will discover the potential of a breach, but not the actual evidence of one. In this light, it is important to note that the wording is breach of security safeguards, not breach of data access. The intent is to record the possibility of a breach, and not just when concrete evidence of a breach is found. It's going to be a challenge for organizations to establish the criteria for including items in this record. The second challenge which I identified revolves around consent and children. In Canada, there just aren't any privacy laws right now specific to children. The changes to PIPEDA by the Digital Privacy Act do not specifically protect children's online privacy, like the Children's Online Privacy Protection Act does for children in the United States. PIPEDA requires organizations involved in commercial activity to obtain meaningful consent, but it may be very difficult to obtain meaningful consent from children. Personally, I'm very concerned about how the personal data generated from my children's online activities is being used, especially when it comes to online video games. Schools have a responsibility to let parents know how they're using children's data. We need a dialogue about children's online privacy that just doesn't exist right now. Thank you for listening to my rant.